This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. All right, so come down a little bit of a rabbit hole with me. This was widely reported today, and it was pretty outrageous, so I thought you'd like to hear about it too. God, this is what the internet looks like when you don't have ad block? Holy mackerel, guys. Why are you doing this to your content? This is horrible. HOA, Homeowners Association in Arizona, forcing teen who lost both parents out of 55 plus community. I thought maybe we should discuss this one a little bit because this is pretty outrageous. It is reported that an Arizona teenager who lives with his grandparents is being forced by the Homeowners Association to leave the community. Colin Clabaugh, 15 years old. The family took their grandson in after both his parents died 2 weeks apart from one another. The grandmother says it's amazing how one rule is more important than one person's life. We didn't plan this. We didn't go out one day and say, let's have Clay kill himself and Bonnie die, and then we'll take Colin in. And to heck with the HOA, it's not the way it was planned. And she says it seems heartless. Even though we've explained our situation, they say the rule dictates everything, and they can't take into account someone's life. The board must balance all the interests of the parties involved, not just the Passmores, who are the grandparents. And then she says, I've stepped in things I find nicer than you people, referring to the HOA and the board. So let's take a look at the letter that they received. Thank you for your October 11th, 2019 letter. Your general understanding of the association's position is correct. The board expects the Passmores to be in compliance with the association's age restrictions by June 30th, 2020. In other words, they expect that the Passmores will have made alternate living arrangements for Colin by that date. I would also like to take this opportunity to clarify the association's intent with regard to Colin's use of common areas. The association's intent was simply that Colin be accompanied by one of his grandparents when utilizing the pool or the clubhouse or other recreational amenities, the same as any guest who would use those facilities. So he's a guest and he's not allowed to be a resident. The association's intent was not to require a chaperone everywhere Colin goes or to prevent him from walking to and from the mailbox, as the Passmores have suggested. As I've previously indicated, the board is sympathetic to the Passmore situation. Now, here's the difference. Are they sympathetic only in words, or are they also sympathetic in their deeds? This is a common thing I see, and you can say all the words you want, but if your actions are contrary to your words, then I don't believe your words, and I don't believe your sincerity. All of the board members understand that these are difficult circumstances. However, the entire reason for the community's existence as an age-restricted community is to allow for deed restrictions that restrict children from residing in the community. The Housing for Older Persons Act allows for the operation of such deed restrictions, and the association is not acting outside of the scope of the law. The board must balance the interests of all parties involved, not just the grandparents, Passmores, but all of the other residents who purchased property in an age-restricted community expecting the age restrictions to be followed. While some association members have expressed support for Colin's residency, others have not, and have indicated to the board that they expect the age restrictions to be enforced and that they may take action to see that the age restrictions are enforced if the board allows Colin to reside in the community for an extended period of time. These sound like really classy people. Wow. So members have indicated to the board that they will take legal action to see the age restrictions are enforced if Colin is allowed to reside in the community for an extended period of time. Wow, what trashy people. Arizona law places a duty on the association to enforce its restrictions, including restrictions on underage residents. The duty is not optional, they say. Now, the Gfeller versus Scottsdale Vista Northern Townhomes Association case was about the association's affirmative duty to enforce drainage requirements. So that's something a little bit different than an age requirement, but it does seem to say that there is some kind of affirmative duty to enforce the requirements. Similarly, the Johnson versus Point Community Association case was about the deed restrictions on stucco. They changed the texture of the stucco in violation of the homeowners association. So I guess these cases do say that there's some kind of affirmative duty to enforce the bylaws, but I still say that they're enforcing bylaws that they themselves made, and they themselves have the power to make either an exception or change the bylaws, that when there's a 16-year-old kid who has lost both parents within 2 weeks, that it's okay to let him live with his grandparents for a couple years while he finishes his adolescence. But, that's a difference of opinion, and they do apparently have the basis in law to do this, and there's nothing that anybody can do in law. So really, it's just, should they really use the law as a reason to be so discompassionate with this child? That's really the disagreement with me. The Passmores' request that Colin be allowed to reside in the community until he is 19 is asking the association to ignore one of the community's most fundamental restrictions, and by doing so, risk a breach of duty claim against the association and by other residents. It also asks the association to risk undermining the age restriction's effectiveness in the future by allowing for claims that the restriction has been waived. At this time, the association is not willing to assume those risks. Because the community is age restricted, another owner could reasonably expect that the age restrictions will be followed. Granting the waiver could materially interfere with that expectation. The board has given the Passmores 1 year to make other living arrangements for Colin because of the circumstances in this matter, but the association cannot grant an additional 3 years. They're asking, so what are they asking for? He's 15 now, and I guess he's going to be 16 or very shortly be 16, and they're asking for them to allow him to live there till he's 19, where I believe the law kicks in differently, and 19-year-olds can live in this age-restricted community or something. In coming to this decision, please understand that the association has no ill will towards the Passmores or Colin. Remember, words versus deeds. Nor is it trying to make a difficult family situation more difficult. It's not trying to, but it is. But on balance with all the various interests, the board cannot grant the waiver requested. In conclusion, the board will not extend its June 30th, 2020 deadline at this time and expects the Passmores to be in compliance with the association's age restrictions by the deadline. If the Passmores would like to propose other options, the board will happily consider those options. The board is willing to meet the Passmores in person if necessary. I don't know. I would like to meet the board in person. I would like to become a poo flinging monkey and start flinging my poo at the board for having such lack of compassion for a child, a grown child too, a teenage child who lost both parents. And the board seems to be assuming that the grandparents who have taken him in will just be able to make other arrangements for a child to live someplace. Really? Or do you I mean, it's possible there is such a thing as an emancipated minor and all that, but that's a minor who's not dependent on his grandparents. So I don't know exactly how proper it would be for somebody to have to get him an apartment at 16 years old so that he doesn't have to live in the gated, age-restricted community illegally. So I thought we could take a look at a couple of these things. I've had people ask me, can this really happen? Yes, there are such a thing as age-restricted communities, and there is a law that makes that not necessarily or not automatically a violation of the various protected classes and things. So what is this called again? This is the Housing for Older Persons Act. Let's first look at that one. Questions and answers. Title 8 of the Civil Rights Act of 1968, as amended by the Fair Housing Amendments Act of 1988, prohibits discrimination in housing on the basis of race, color, religion, sex, national origin, excuse me.
I identify as an Armenian.
I identify as a Luxembourger. Prohibits discrimination on the basis of race, color, religion, sex, origin, handicap, and family status In general, the presence of children under the age of 18. The prohibition against discrimination based on family status became effective March 12, 1989. The act contains a provision exempting senior housing from the prohibition against familial status discrimination. The Housing for Older Persons Act, signed into law by President Clinton, 1995, amended the Housing for Older Persons exemption against familial status discrimination. The HOPA modified the definition of housing for older persons as housing intended and operated for occupancy by at least one person 55 years of age or older per unit. All right, I just wanted to break in here for a quick minute and explain that I'm about to get the analysis wrong, and then one of our audience members will point out what I missed, and I'll correct it by the end of the thing. So they are allowed to discriminate against people under 19 years old. I don't like it, and you can see me trying really hard to fight against it, but I was wrong, and I want you to see how it happened, so I'm leaving it in. So, whoa, wait a second. Housing intended and operated for occupancy by at least one person 55 years of age or older. It sounds like the Passmores are 55 years of age or older. So that's not it, right? They have at least one person in the household 55 years or older, so that's checkmark. They've met that requirement. Where does it say a 16-year-old or 15-year-old can't live with them? It eliminated the requirement that housing for older persons have significant services and facilities designed for its elderly residents. It required that facilities or communities claiming the exemption established age verification procedures. It established a good faith reliance defense or exemption against monetary damages for person who illegally act in good faith to exclude children based on the legitimate belief that the housing facility or community was entitled to the exemption. One more time. It established a good faith reliance defense or exemption against monetary damages for persons who illegally act in good faith to exclude children based on a legitimate belief that the housing facility or community was entitled to the exemption. Okay, so there's going to be evidence and testimony about what they knew and when. What is a housing community or facility? It is a condominium association, a cooperative, a homeowners association, so that matters. May an owner of a single family house that are dispersed throughout the area who is not otherwise exempt qualify as a housing community? No. What must a housing community or facility do to qualify for the 55 years or older exemption? At least 80% of the occupied units must be at least one person 55 years or older. So unless this one child is going to destroy their 80% ratio, I don't think that's a problem. The owner and management of the housing facility must publish and adhere to policies and procedures that demonstrate an intent to provide housing for persons 55 years and older. The facility community must comply with rules issued by the secretary for verification of the occupancy, so surveys and affidavits about ages. What are some examples of policies? Written rules, lease provisions, deed restrictions, actual practices, advertising, and age verification procedures. May a housing facility or community advertise as adult housing and still demonstrate an intent to house older persons? The use of the word adult or adult community does not demonstrate the intent, so that's not it. How many days after the effective date? I'm not too worried about that. What information should a housing provider include in its survey to make sure they meet the 80% requirement? The number of units that have been continuously occupied, the number of unoccupied units, the number of units occupied by employees of the housing facility who are under 55, and the number of units occupied solely by persons who are caregivers. What is considered reliable age verification? Driver's license, passport, birth certificate, self-certification sometimes. What is the recourse for an owner if the occupants in a household refuse to cooperate? And that's in the documentation of their age. That's not happening here. Everybody knows that the grandparents are old enough and the child is not. Just the child is not old enough to meet the 55 requirement for the 80% ratio. That's all that means. So far, I don't see anything in here about 15-year-olds. I'm thinking that this is an actual homeowners association policy and not a law, not a legal policy. Because remember, they've based it on the law. They're saying that this Housing for Older Persons Act is the basis for their acting this way. What does the ratio mean? HOPA requires that at least 80% of the occupied units be occupied by at least one person 55 or older. The remaining 20% of units may be occupied by persons under 55 and still qualify for the exemption. So these people appear to be wrong about this part of the law, at least. Is it lawful to market the 20% to people under 55? Yes. However, the marketing must be done in a way that identifies the community as housing intended for older persons. May a housing facility or community impose age limitations more restrictive than that required by the HOPA and still qualify? Yes. For example, the housing facility community may require that at least 80% of the units be occupied by at least one person 60 years of age or older. The housing facility community may require that 100% of the units are occupied by at least one person 55 years of age or older. However, the facility should review other state and local laws, including fair housing laws that may prohibit discrimination based on age, before establishing policies and procedures restricting occupancy based on age or affecting survivors' rights to property that are not covered under HOPA. So that says to me that they can issue a restriction, but it still must be the kind of thing where it only requires one person to be of a certain age. And here we have two people who are of that age and then a 15, 16-year-old. So I don't see any problem with the 15, 16-year-old living there with his grandparents and without having to have an escort to the various housing-related recreational activities. So far, this actually does seem like some kind of age discrimination. If a 55 or older occupant dies and leaves her property to a surviving spouse that is under 55, what rights do they have? The right of possession by a surviving spouse is not governed by the HOPA or Fair Housing Act. Whether an underage heir or surviving spouse can occupy the unit upon the death of a 55 or older occupant is a matter of state law or custom and is generally governed by private contractual agreements between senior housing developers and the individuals who purchased the rented the dwelling. The provision in the Act permitting 20% of the units be occupied by persons under 55 is intended, in part, to prevent a housing facility or community from losing the exemption due to situations where there are surviving spouses and underage heirs. So the 20% is meant to allow them to do that, to maintain their homeowners association is not under threat, at least not through the act that they cited. They did not cite bylaws that say that the kid can't be there. And even then, I'm not sure that wouldn't violate some kind of age discrimination law in Arizona.
As far as I can tell, all this law says is that they can restrict it. It doesn't say that they have to.
And even then, the restriction just seems to be an age restriction on the one person in the household must be at least 55 or 60 or whatever.
Yeah, but my point is that they're using this law as a shield, right? Like, oh, don't yell at us. It's the law that's telling us to do this, but it isn't. They're deciding to make this
it's their own
decision
policies,
themselves.
not the law, it appears.
Yeah.
Can the facility evict families with children during a transition period while becoming housing for older persons? No. The housing facility can renew or not renew leases for families with children if doing so does not represent a change in its practices or does not violate state or local law. And that's just for a transition period when they're transitioning into being a housing for older persons community. So that doesn't apply here. They're already that community. If an individual files a complaint based on familial status and the housing community facility claims the exemption as a defense, who has the burden of proving that the community is in compliance with HOPA's requirements? The community facility housing provider has the burden of proving that it was in compliance. So they could very easily simply comply with this law, and then if they got sued by somebody for violating this law, they would just have to prove that they are still within the 80-20 rule. And they are, because remember, the 80-20 rule doesn't apply to Colin because he's living in a house with two people who qualify to live in that house. The violation would be if it was people under 55 or under the age restriction, that there was nobody over the age restriction in the house, then that would become part of the 20%. And if the 20% became more than 20%, that's when they'd be in violation. An individual is not liable for monetary damages if the person acted with a good faith belief that the housing facility or community qualified for a housing for older persons exemption. So even if they're outside the exemption, as long as they believe they're in it with a good faith belief, which is a sincere belief, you've looked into it and you think you've got the right answer, then you can't be liable for monetary damages. How are state and federal fair housing laws that prohibit age discrimination affected by HOPA? Neither the Fair Housing Act nor HOPA covers age discrimination. Neither of these federal laws supersede or otherwise affect state or local laws that prohibit age discrimination. So let's look to see if there's an age discrimination law in Arizona. The Fair Housing Act does not require a older housing community facility to join a homeowners association, so they don't have to have a homeowners association. Okay, and that's the end of that. Let's see what we can find about Arizona's age discrimination. The state's fair housing laws are equivalent to federal laws. In some communities, local ordinances make it illegal to deny housing based on age, marital status, or sexual orientation. Actions prohibited under the Fair Housing Act: refusing to show, rent, sell, refusing to negotiate, charging more to buy, requesting a larger security deposit, telling a property is no longer for sale when it really is, advertising that a certain type of person is wanted, denying services that are available to others, so that might be one of them, insisting that a family live in a designated area, or maybe insisting a family not live in a designated area, denying access to the use of the facility that is normally available, so that's been done, telling owners and residents to move because the neighborhood is being integrated by minorities, suggesting that a person move to a specific area, unlawful bias on an appraisal, providing different terms and conditions for a mortgage, refusing to permit reasonable accommodations for assistive aids, assistive animals, parking, physical modifications, failing to provide wheelchair access, engaging in retaliation or discrimination against a person who complains about discrimination, and harassment. So I don't know exactly whether any of those fall under the Fair Housing Act. It does say race, color, sex, religion, origin, family status. So I think that's discrimination based on family status. At least these would be things I'd be looking into.
I know historically family status is usually tied to whether or not you're married, but of course case law could have broadened that drastically.
The Gardens at Willow Creek has responded again and said the Gardens recorded declaration and both Arizona and federal law provide that the association is an age-restricted community, meaning that individuals under 19 years of age are prohibited from residing within the Gardens at Willow Creek. That is not how I read the law that they cited. They cited the HOPA, and the way that I read that was that the age restriction is that one person must occupy the house who is over 55. The association is governed by a volunteer board of directors. Are we starting to see the problem here? There's a board, and they think they've got power, and a little bit of power goes straight to people's heads. And it's made up of elected owners of property in the association. The managing agent takes direction directly from the board. The board takes its own responsibilities under the association's governing documents, as well as the concerns that owners express seriously. The board appreciates the difficulty of these circumstances, but must balance the interests of all parties involved, the Passmores and all other owners who purchase property in an age-restricted community expecting age restrictions to be followed. Again, they seem to misunderstand what the age restrictions are. Everybody in the community, every unit, or rather, it's not even every unit, 80% of the units in the community have to be occupied by someone 55 or older. That's it. That's all that the law requires. If they have something more restrictive, I haven't seen what they've cited for that yet. I don't see their bylaws or whatever that say that they have the right to do this. And even if they have bylaws, the bylaws are written by the board or whoever chartered the homeowners association, and then the bylaws are maintained by the board. And so they're responsible for them, and those have to comply with the law. So far, and I could be missing something here. There is room for me to be missing something, but so far it seems like this is illegal discrimination against the 15-year-old child, and that they just don't want a kid around, so they are trying to enforce some kind of homeowners association regulation, not some kind of law. It doesn't seem like the law supports this at all, really. The board appreciates the difficulties of all, but the age restrictions must be followed. Generally, community associations that fail to enforce their residency age restrictions leave themselves open to legal claims from other residents who could even endanger the ability of the association to remain an age-restricted community. That is not what we just read, was it? That is not at all what we just read. It in fact said that there is no monetary liability for someone who challenges whether a HOPA community is really a HOPA community or not. Yes, it does put the burden on the board to then respond and prove that there's still a HOPA community, but that's the board's job in the first place, to have all those records and everything. So they just have to compile the records and send them in, and they won't do that for a 15, 16-year-old child who lost both parents. Apparently lost both parents, one to suicide after or before the other died of illness or old age or something. Or no, I guess they were parents, not grandparents. So somewhere in the middle there, it seemed like someone died of, I'm guessing, an illness or something else, and then the other person may have committed suicide, which is not something that I would want to. That's a reason to be compassionate with the 15-year-old. That's a reason to go out of your way and be compassionate with the 15-year-old. That is a horrible situation, and it's a situation that requires humans to be compassionate with one another, not for homeowners associations to stretch their wings and flex their muscles and visit their authority on a 15-year-old kid. A 15-year-old kid who appears to be living in the community in compliance with the Housing for Older Persons Act. But they continue. The board believes it has appropriately balanced the interests of all parties involved. While the board strives for a sense of community, the board recognizes that residents may have a different perspective regarding how association matters are handled from time to time. As offered on several occasions, the board is willing to meet with the Passmores to discuss this matter in further detail and will continue to evaluate information regarding this situation as it is provided. So, I still feel firmly that these are trashy human beings who are trying to use their authority to please the owners of their community when that is not what the law requires. Instead, they could simply explain that the child is allowed to live with their grandparents, at least under the HOPA. I have yet to see what law they think they're actually acting under. I will look at the two cases separately tomorrow and post my analysis along with the this video. So what do you think of that? Yeah. You think Ewan thinks that they are legally allowed to do it.
So my issue here is not that they're not allowed to do it. Like, I'm sure that they are allowed to do it, and based on what we read, it says that they're allowed to do it. The problem that I have is that they're using that law as a shield to say that they are required to do it, where really what it is that they want to do it. And they're telling everybody, hey, this law says we have to kick him out. But that's not true at all.
I agree that they are trying to pass the responsibility, or like they're not taking responsibility for the decision. They're not owning it. They're trying to say that they're obligated, but they're not obligated. They've just chosen to until they cite a different law.
Yeah. Now, even if the homeowners association has a rule that only 19 years and older is allowed, I don't see how that doesn't violate some kind of familial status anti-discrimination law when this is a child who has lost his parents, and so their family status is that he doesn't have parents. That seems to me pretty clear, but I'm not a family housing law attorney. I'm not a Fair Housing Act attorney. I'm not a HOPA attorney. I'm just a copyright attorney who is outraged by this situation. Now, follow me out here then, if the homeowners association has made the rule that only 19 years and older people can live in the community, and if under some law that is somehow legal, well, it's still their rule. Don't you think that in the face of a horrible situation like this, they could simply vote to alter the rule? And they don't. So I'm calling them trashy and saying that this is a situation where we should hope people would be compassionate, but we should require them to be legally compassionate in this case. Not by law in the we have to override everything that a homeowners association wants sense, but rather this seems to me to be some kind of illegal discrimination under Arizona law and under the federal law that protects people from family status discrimination.
I also wonder if the people who are concerned about having a 15-year-old in the community are aware of the background story. Like this was obviously a very horrible situation that was not his choice, that he has no wrongdoing. And the most, I want to use the word just, I don't know if that's the right word to use in this, but the most compassionate take is to allow him to live there and with family.
Once you meet the 80% minimum, then you are allowed to discriminate. I don't think that's what that says. The 80% minimum means you get to call the community an adult community, and you get to market towards seniors, and you get to enforce the rule that 80% of the units are occupied by at least one person 55 or older. The Housing for Older Persons Act, signed into law, amended the Housing for Older Persons exemption against familial status discrimination. Okay, it does say familial status discrimination, but did it amend it for all kinds of familial status, or only the one that prevents them from advertising it as an adult community? The housing must be occupied by at least one person 55 years of old. So how can it say that they have an exemption against familial status discrimination as long as they occupy a house by at least one person 55 years or older? So they've met that. The grandparents are 55 years or older. It eliminated the requirement that housing for older persons have significant services and facilities for elderly residents. It required that facilities or communities claiming the exemption establish age verification and have good faith reliance defense against monetary damages. Nothing in here says that they are allowed to require no children. It says one person must be at least 55 years or older. Housing for older persons is at least 80% occupied by at least one person who is 55 or older. So Collins' family meets that. The housing facility and community publishes and adheres to policies and procedures that demonstrate the intent required under this subparagraph. The housing facility and community complies with the rules to verify occupancy. They use surveys and affidavits. They include examples of the type of policies and procedures. A good faith attempt to comply with the act. Okay, we've seen that. Let's try here the summary. It is legal for communities to market themselves as age-restricted or 55 plus, provided they maintain the 80% of the occupied units are occupied by at least one person 55 years and older. The community could lose its age-restricted status, which is what they said in the thing, if it falls below the 80% threshold, which Collins' family is not going to cause it to do because they have 55 plus people in the home. In most adult communities, no one under the age of 19 may reside in the community unless granted an exemption. So they could grant them an exemption. However, at the community's discretion, the age minimum may be higher or lower. Okay. Furthermore, most communities stipulate that if anyone under the age of 55 resides in their community, they must live in a household where at least one occupant is 55 or older. Again, that's Collins' situation. Nearly all age-restricted and active adult communities allow people under the age minimum, such as grandchildren, to visit on a limited basis. Most age-restricted communities have covenants that allow people under the age minimum to reside temporarily in the community from a period of time ranging from 2 weeks to 90 days per year. It does appear to say that they're allowed to discriminate up to age 19, but it also says that they can easily grant an exemption, and it appears to be that they are trying to say that they're not going to do that, but they're hiding behind the law. I still think they're trash, but it does appear that there is at least a legal basis for discriminating against the 15-year-old. I still put it to you, so what is a 15-year-old supposed to do? What are you going to send him to a child's home? An orphanage? Really? It appears that what the Passmores are looking at doing is actually having to sell their home and move into a non-age restricted community so that that's now 16-year-old can live until 19, and then they can go back to an age restricted community. What a horrible situation. I definitely would be contacting my Arizona congressman or whatever and communicating my feelings on this issue. Okay, here we go. The Act contains a provision exempting senior housing from the prohibition against familial status discrimination. But even familial status, I guess it doesn't say age on here. So that is pretty horrible. That is a really horrible result. So if you are an orphaned child, you can't go live with your grandparents in an age-restricted community if they are discompassionate pieces of trash that refuse to allow an orphaned child to live with his grandparents. And by trash, I mean they have the ability to be compassionate and they are refusing. And no, you're not going to convince me that, because it's a vote, that means they're allowed to hide behind each other. No, the community voted through their elected board members to this homeowners association. They voted for people that are less compassionate than I would like them to be. And that's why I'm calling them trash. I would never, I just simply cannot believe that these older people are so upset by one 15-year-old child that they are going to kick him out despite the circumstances of his parents' death. That's pretty horrible. That is really, really horrible in my opinion. So that is our show, everybody. Let us know what you think in the comments below. Thank you to Tactical and Brandon for joining me on the stream. And thank you to our $50 plus supporters for the month of January. Thank you to Apernari, John Steele, Gavin Barnard, Kyle Mudrak, Michael Pearce, Jan Negrey, Spirit Bear, Daniel Perez, Snorre Wisotzky, Blackleaf, Joe Tyson, Eevi, Benjamin Hitov, Steven, Cute Grills in Your Area, and Ottah. And thank you to the $5 plus supporters who are scrolling on the screen in front of me. I love you all. I will see you in the videos that drop. I'm Leonard French, your favorite copyright attorney. Have a good one. Bye. All right, so we'll have to heavily edit the that last story. Maybe, it's okay that I came to the wrong conclusion and then eventually came to the right conclusion. That might actually be a twist that people won't appreciate, and they might have feeling a way about it. What a twist! All right, guys, I really got to go to bed. I'll see you tomorrow. Bye. That's too soon. Let's go on. How cool is that?